We are live. Greetings, my brothers and sisters all over the world, whether you are in Nigeria or in the diaspora. I bring you warm greetings. This is Nigerian Constitution and Your Right. Nigerian Constitution, Know Your Right, a program powered by the Global Coalition for Security and Democracy in Nigeria. And today's topic is a continuation of the conversation we started last Tuesday. Okay, the topic is Peter Obi and LP versus INEC, Bola Tinubu, Kazim Shettima, and APC. Part two, because last Tuesday was part one. Okay, last Tuesday was part one of the conversation. We only handled one of the ground of the petition. So this is about the Peter Obi petition against this the four respondents that I mentioned in the topic. Okay, so that is what we're continuing today. As I mentioned, in my brief summary, I mentioned that this petition is Peter Obi and LP versus Bola Tinubu, Senator Shettima, INEC, and APC. That's the All Progressive Progressive Congress. Okay, and the petition relied upon about 52 documents, which include the various INEC forms, the result sheets in both physical and electronic forms, and it also relies on ballot papers. It relies on the certified true copies of voters register, certified true copies of the letter to INEC chairman for BVAS report, the certified true copies of the BVAS report itself, certified true copies of all the list of INEC officers and ad hoc staff used for the election in all polling units, and also the approved guidelines and regulations for the conduct of the election 2023. Okay, so these are what is relied upon for by the Peter Obi and Labour Party in this petition. And I have a guest with me tonight that will help make sense of this petition. And let me invite the guest to the studio as we continue the conversation. Welcome, UC Maxwell. Can you introduce yourself to the audience? I know you were here with me last Tuesday and we covered just one ground, and we're gonna hopefully cover the remaining two grounds today. Introduce yourself as we dive into the conversation proper.
Good evening, ladies and gentlemen. Good evening, Dr. Edmond. It's a pleasure to be here once again. I remain UC Maxwell, founder of Law Depth Foundation. Thank you.
Thank you very much for that wonderful introduction, and thank you for coming to the studio to continue the conversation. And Rita English is here in the comment section saying, "Hi everyone, nice to be here again." It's nice to have you in the background, Rita. Continue coming back and ask questions. If you have any question about the petition as we discuss it, also ask question about it. And Oge Steffi says, "Welcome back." Thank you, Oge. And I hope you ask question about the petition as we continue with the conversation. All right, so I've given a brief introduction or brief summary of what the petition is about. And from last week, Tuesday, we mentioned that the petition is based on 3 grounds, okay? 3 grounds. And these 3 grounds are ground 1, that the respondent, okay, maybe let me go back to who are the respondents again. For those that are just watching this part 2 without watching part 1. So the respondents in this petition, the people who the petition is against, and these respondents are INEC, that's the Independent National Electoral Commission, that's respondent 1. Then respondent 2 is Senator Bola Tinubu. Then respondent 3 is Senator Shetima Kazim. Then respondent 4 is All Progressive Congress, that's APC. So those are the 4 respondents in this petition. So if you hear respondent 1, we're talking about INEC. If you hear respondent 2, we're talking about Bola Tinubu. If you hear respondent 3, we're talking about Senator Shetima Kazim. And then the petitioners are those who petition against this respondent. And the petitioners are, if you hear petitioner 1, we're talking about Peter Gregory Obi. And if you hear petitioner 2, we're talking about Labour Party. Okay, so that's a brief recap for those who are just watching this part 2 without watching part 1. And then the grounds now. The ground 1 says the second petitioner was at the time of election not qualified to contest. That's ground 1. And we have covered this ground last Tuesday. Then ground 2 says the election of the second respondent was invalid by reason of corrupt practices or non-compliance with the provision of Electoral Act 2022. That's ground 2. Then ground 3 is that the second respondent was not duly elected by majority of the lawful votes cast at election. So those are the 3 grounds. As I mentioned, we have covered ground 1, and today we are going to cover ground 2 and 3, and we'll wrap up this conversation. So now, back to UC Maxwell. Do you believe that INEC follow the provisions of the Electoral Act, and tie that to the ground 2 of the petition that says that the election of second respondent was invalid by reason of corrupt practices or non-compliance with the provision of Electoral Act 2022?
Okay. The Peter Obi's petition is hinged on 2 major arguments, which is a failure to comply with clear provisions of electoral laws or guidelines, as the case may be, that provide for the conduct of these elections. Then on another hand, the second argument under this ground is saying that there were corrupt practices during the elections, which on this basis the elections should be cancelled. The first one is simply saying unequivocally that there is no compliance of the provisions of the Electoral Act. Now, the major provisions that they are arguing is section 64, subsection 4, 5, 6 of the Electoral Act. We have clause, I think, 37, 38 of the regulations and guidelines for the conduct of elections 2022, and some other regulations that were released, manuals for the conduct, and some letters or correspondences or memos which INEC put out to the public before the elections. You would recall that the president or the chairman of INEC had held several meetings, several conferences where he assured the general public that there will be transmission of electoral results real time. Now, in the wordings of the Peter Obi's petition, they are saying that INEC failed to comply with these guidelines, section 64 of 4, that says that anytime that there is a conflict between results, that you must check that conflict with what is already uploaded at the IREF, that's the viewing portal. So there was no real-time upload. And in the words, if you check paragraph 52 of that petition, they said that the word instantaneously was the main thing. That results which were instantaneously uploaded at the earliest moment ought to be the standard for assessing other results. So there was no instantaneous upload. At least majority of the results were not uploaded. That is a violation of the provisions of section 64 and clause 37, 38 of the regulations and guidelines for the election. You would also recall that that during these same elections, that they said that they would come on time, that they were going to close voting by 2:30 and all of that. They didn't come on time. These are within their regulations, though not really, in-depthly analyzed in the petition, but it is hinged on this particular basis. And for this, the petitioners are going to be subpoenaing that's the staffs of Amazon Cloud Platform, where there was an upload, to dictate why there was no upload, real-time upload for these results. Then when you look at it, you would see that INEC indeed failed to keep with the dictates of the law, the guidelines which they released by themselves, memos which they had canvassed, at different forums, and also the Electoral Act, which is the major law that guides the conduct of elections in Nigeria. In another argument, talking about the what do you call it now, the illegalities that existed, or the fraud that existed during the election, still under that ground too. They are saying that there were a lot of corrupt practices. There was a lot of emphasis on River State and Benue State, saying that there were deductions from the voting or from the results of Labour parties. There were alterations, there were manipulations of election result. That is the form EC8A. And on this twin basis, the petitioners are asking that the court should deem this election as fraudulent, because according to the famous Lord Denning, in the case of McFoy versus UAC, he said that you cannot put something on nothing and expect it to stand. It will definitely fall. So where a clear provision of law has been violated, where a law provides for a process of doing something, and that process is violated, and you continue to do that thing, it is deemed that you have made an attempt to put something on nothing. So no matter how well you do that thing, no matter how well INEC continuously announced that result, because there was a failure to comply with the provisions of the statutes of electoral laws, it will be deemed illegal for that particular violation. So this is what the petitioners are canvassing before the courts and arguing that on this basis, we saw a lot of malpractices, we saw a lot of alterations of from EC8As in different polling units. We saw some uploads. For instance, in Imo State, there were some uploads from Sokoto State results were uploaded in Imo State, polling units on the IREF. So these are a lot of corrupt practices that existed, and these are the arguments of the petitioners before the Presidential Election Tribunal.
Thank you very much, UC Maxwell, for that wonderful response and analysis of the second ground of the petition. Yeah, you covered it really well. And please, audience watching or listening from whatever platform you're listening from, if you have any question or whatever explanation that you receive about this grounds on which the petition is based, you can type your question in the comment section, and we'll do our best to answer. I'll be happy to answer your question. Also, the learned UC Maxwell will also be happy to answer your question. All right. So utilize this opportunity. This conversation is for all of us to be part of it, because it's going to be consequential to what happened to us as Nigerians going forward. As the mandate of Peter Obi is restored, or what happened going forward if the mandate is not restored. So pay attention, ask questions, anything that is not clear to you, try to have it clarified before the end of this broadcast. All right. Then my next question now. If this third ground, we're going to the third ground. The third ground says that the second respondent was not duly elected by majority of the lawful vote cast on election day. So what is this ground trying to imply according to the petition? And is that implication based on law? Please, what's your opinion on that? Or what's the analysis on that ground?
Okay, the electoral. Okay, can you hear me?
I can hear you.
The Electoral Act has made provisions for the grounds upon which a petition can be brought. And one of it is that where a person was deemed elected, but not by lawful votes, majority of lawful votes, very important. So on this third ground, the petitioners are canvassing that the APC, Bola Tinubu Shetima tickets were not elected as a result of majority of lawful votes. So it is possible that they got majority votes, but the argument is that these majority votes are not lawful votes. And one of the very, very important arguments under this particular ground is the basis of the FCT. Recall that Section 137 or Section 134, subsection 2, provides that for a person to be duly elected, that the person must have scored majority votes and gotten a percentage of, getting 25% percentage in 2/3 of the states in Nigeria and the FCT. So the petitioners are arguing that the APC as a party failed to get the required 25% in FCT. So INEC going ahead to declare him as the president-elect this ground. How can you declare, according to the petitioners, a person who has failed to get 25% in 2/3 of the states and the FCT? By the result, they were able to get this percentage in other states. But there is a constitutional requirement going by the provisions of Section 134 that there is a need to get 25% in the FCT. That there is a need because Abuja, being the Federal Capital Territory, is a constituency on a federal basis. So if you must be a president, you must be able to get 25% from your seat of power, being the Federal Capital Territory. And BAT failed to get this required, this required 25%. You would recall that a lot of, legal luminaries have argued, they've thrown the weight of their arguments towards different sides of this particular opinion, that there is a necessity to get 25% in Abuja, and others have said there is no need to get 25% in Abuja. And this what make the petition juicy, because we'll be seeing a landmark decision by the tribunals on this presidential election and possibly at the Supreme Court, which is very, very important. Also noting is the fact that recall that there was overvoting. In the petition, the petitioners were able to highlight a lot of states, including Kwara, Gombe, Rivers, Kano, Taraba, and many other states, where there were clear evidences of overvoting. But INEC refused to cancel these results in this, violating the clear provisions of the Electoral Act, which requires the cancellation of results where there is manifest evidence that there was overvoting in any polling unit. So they failed to do this, thereby accruing majority of unlawful votes to Bola Tinubu and the APC, thereby declaring him president. So these are grounds. Another thing under this ground that the petitioners argue are the issues of the glitches in the two uploads of result through transmission, one to the back-end server upon which Amazon controlled, and one to the IREV, the viewing portal for the public. Evidences show that there was no clear upload and in the back-end server. And that is why the petitioners will be sending or will be requiring a subpoena from the court to subpoena those who work in this Amazon security network. Truly, there was a glitch at the system at this time, which was not able to enable the transmission of results and uploads from the polling units. And upon these things, the petitioners have made a lot of prayers to the court. Ground 3 is very, very strategic, very, very strategic, as it maps out a new a paradigm shift to leg.
Are you there, UC Maxwell? Please, audience, keep sending your question in the comment section. If we are trying to cover the ground number 3, on which the petition is based, the petition of Peter Obi and Labour Party versus INEC, Bola Tinubu, Kazim Shettima, and APC. We have covered ground 1 and ground 2. We are currently talking about ground 3, on which the petition is based. Are you there, UC Maxwell? Are you here, UC Maxwell? I think it's having some internet connection challenge. So once again,
can you hear me?
Yes, I can hear you now. I can hear you now. Yes. So you're
okay. I don't know if you got to the final part of my submission.
No, we didn't get the final part that you were saying. The petition is trying to accomplish like a groundbreaking something in the legal system of Nigeria. That last part.
Yeah. You know, yes, there have been several arguments regarding the issues of, the requirement of the 25% vote in the FCT. And this particular court case is going to be a landmark decision, owing to the fact that it will clear the various ambiguities regarding the need for 25% vote in FCT, whether it is indeed, the aim of the lawmakers or not. So it's very, very important.
Okay, yes, that is true. It's very, very important. But however, I heard an argument that this has been settled in one judgment in the past, whereby the judge clearly stated that 25% is needed in the FCT for a candidate to be declared winner of the presidential election. It has been decided by the court at some point. But still, there's still the argument that no, based on a provision of the Constitution, I think in section 200 or so, that the FCT is to be viewed as one of the states in the federation. And if you view the FCT as one of the states in the federation, that means 2/3 of 37 states is as long as it gets 2/3 in the 37 states, whether in FCT or not, whether FCT is including that 2/3, that you still can be declared the winner. So yeah. So what is your take on that argument that FCT can be considered as one of the states? I think UC Maxwell just dropped off. He's been having connection problems. But as I was saying, there has been two arguments about the 25% requirement, that the Constitution made it clear you have to have 25% in 2/3 of the states in the Federal Republic of Nigeria to be able to win the presidency. Okay, so now Peter Obi's petition is indicating that it's a must to have 25% in FCT to win the presidency. While the people on the other camp, APC specifically, and Tinubu, Senator Shettima, Kazim, are saying that, and INEC, of course, are saying that FCT is to be considered as one of the states in Nigeria, and hence it's not must to get 25% FCT to be declared as a president. So those are the two arguments here, and that was the point that UC Maxwell was trying to make, that as soon as the judgment is made, that will be groundbreaking, because that will settle the issue on, is FCT truly required? Do candidates truly required to have 25% of the vote in FCT in order to win presidential election? So everyone is looking forward to the decision of the tribunal in this case, especially on this third ground, which is talking about that the second respondent, which is Bola Tinubu, was not duly elected by majority of the votes, of lawful votes cast on election day. Okay, and that was hinged upon FCT. That Tinubu did not get 25% in FCT. That is true. What is his name? Atiku Abubakar, I think he also did not get 25% in FCT. Only Peter Gregory got 25% in FCT, and Peter Gregory also won FCT. All right. I think UC Maxwell is back. UC Maxwell, I think you're having some internet connection challenge. My question to you is about, what do you think about the people on the other side, usually APC folks and INEC, making an argument that FCT can be considered as one of the 36 states according to the Constitution. So hence, the 25% in two-thirds of the states still is 24 still means that FCT is not a requirement. What do you say about that argument?
Well, there will always be arguments and counter arguments before the court of law, but I want you to know that where the courts, in various judgments where the court said that FCT is to be considered as those judgments were not in relation to electioneering, if they were not in relation to election results. I don't know if you understand me. So a case must be considered on its own merit according to the events and circumstances that surround that case. Considering the FCT as a state is for administrative purposes. Governor, you see that the president as the governor of FCT. That is what the court said, for administrative purposes. But when we talk about in the computation of numbers and election results, it has a lot to do with mathematical calculations. It has a lot to do with interpretation words of the Constitution under Section 134. So they can have the argument. Fine, it's welcome. It's before the court. And like I said, that is why I said this case is very important to, douse a lot of arguments and counter arguments about the FCT. But like I've said, I have always aligned, though I don't like to make my position public, I've always aligned my position with the fact that FCT indeed is a constituency of its own, because a person must be able to win 25% from his constituency. So if the president's seat is based in the FCT, there is a need for him to be accepted by at least a 25% of the FCT. Because if that is not the case, we would have a lot of people who would threaten the seat of power. That is the rationale behind.
All right. Thank you very much, UC Maxwell. You've done an amazing job dissecting the various grounds on which the petition is based upon. And audience, if this is your first time of listening to this discussion, just know that this is part 2 of the conversation. The part 1 was last Tuesday. So if you haven't listened to part 1, go ahead and listen to part 1, because part 1 specifically covered the first ground on which this petition is based. And today we just finished covering the second ground and the third ground, because this petition is based on 3 grounds. Okay, once again, I thank you all for listening. Just for a quick summary, we've covered the 3 grounds. UC Maxwell, you've covered the 3 grounds beautifully last week and this week. So what is your opinion on the petition as a whole? Do you think the petition is well grounded and to be able to help Peter Gregory as a petitioner 1 and Labour Party as a petitioner 2 to win or restore back their mandate? What do you think? That is the first leg of the summary. And the second leg of the summary is, do you think, because that's based on the popular saying that the judges are not Father Christmas, that they only ground their judgment based on the prayers of the petitioners. So do you think that the prayers of the petitioner is enough for the mandate to be restored? or do you and indeed that the judges are not for the Christmas, or do you think there's one more prayer that they ought to have added in order to make sure that the mandate is restored? You see, Maxwell.
Hello, please. I didn't get what you said.
Okay. In summary, okay, we have covered all three grounds, right? So in summary, you've covered, you were here with me last Tuesday and you're here again this Tuesday, and you've done an amazing job covering the three grounds. So I'm saying, based on these three grounds, do you think these three grounds are enough to help the petitioner 1 and 2, that's Peter Gregory Obi and Labour Party, to restore the mandate, the stolen mandate? And because the judges or the tribunal or the justices, they are not Father Christmas, as they always say. They only grant the prayer says it's been sent to them. So does this petition have all the prayers needed to restore the mandate, or do you think, okay, they could have added this prayer, they could have added that prayer to ensure the mandate is restored?
Well, left to me, I would say that the petition is okay. It passes all marks that you want to put, because I told you that the Electoral Act creates a limit as to the grounds for which you can bring an electoral or an election petition. So they've been able to leverage this particular one. Although I had, the mindset that going by the provisions of Section 137, subsection 1, paragraph J, which talks about the forgery of certificates or forgery of anything presented, that a person will be disqualified to hold the position of presidency. I thought that they would leverage this particular aspect on the basis that there have been a lot of claims which are understandable, that the certificates as presented to INEC by Bola Tinubu are forged. So this is the only point I felt that they would have raised, but they are of course learned men in the trade of law. I believe that they've weighed everything possible before leaving this particular one out. So it is a good petition on average, like it is a wonderful petition. It has covered the necessary things you need to cover to restore the mandate of Peter Obi.
All right. I think that's it. That's where we end for today. We have covered the petition in completeness. We've covered all three grounds, which I believe we have covered the petition. It's a very vast petition with over 100 pages. So, and I think UC Maxwell did an amazing job covering all the grounds last week and this week. So thank you, UC Maxwell, for coming to our virtual studio today. Thank you for being magnanimous with your time and your knowledge as a legal mind. Thank you once again, and thank you, our audience, for participating in today's conversation and listening and joining into this conversation. And I hope to see you next Tuesday, 9 p.m. Nigerian time, same place, this channel, 3 different platforms, on YouTube, Facebook, and Twitter. Thank you once again, and have a wonderful evening.